but I've got the official time. And with that, case number 23-214, Landero versus Landero. You can begin.
Good morning. My name is Mark Sessoms, and I represent the former husband, Dr. Landero, in this matter, and I'd like to reserve 3 minutes of my time for a rebuttal. I'd ask the court to recognize I did not try this case. I did handle one temporary hearing, but I was not the trial counsel in this particular case. Mr. Schapani was, however. I understand that Judge Bruning, as it appears from the record, labored mightily on this case. An extraordinary number of hours were devoted both to temporary hearings, I believe 60 hours, and to trial. So I recognize that Judge Bruning attempted to exercise his discretion under adverse circumstances. He specifically found negative findings as to each party's credibility, not just my client, but now the former wife. And just to be clear, he said both parties were uncredible, non-responsive, and elusive, with quote unquote only a loose affiliation with the truth. However, we are not seeking to contend that the trial court misapprehended facts. However, the clear facts and the record indicate that the law was misapplied or was not applied, or that there were errors because the court didn't take the findings of fact that it found and apply it correctly to the law. And you will note from the answer brief that there is a dearth of any citations to the contrary of our positions that are in our appellate argument. So the arguments are many, but I'll try to deal with them fairly quickly. This is a short-term marriage. There's a presumption against permanent alimony. However, the court found permanent alimony. The court, however, was very clear that the wife was a nurse before, during, and after the marriage, and that the marriage itself did not affect her ability to earn income. In essence, what the court was doing was awarding another form of child support. When you look at the math.
But wasn't the court really, the crux of it was relying on the case of Rees versus Rees due to the fact that there's at least one child with, well, two with autism and another with a learning disability. So wasn't the court primarily relying on the factor that related to the disabilities of the children?
Correct, but that's erroneous because alimony is for her own support. The court, contrary to counsel's position, the court said she was earning $40 an hour, working 36 hours a week, and was able to work more once the husband, because she was preventing his time sharing, as the record reflects, once he was able to exercise his time sharing, she would earn more. So it's clear the court found her needs were $8,000 and she was making $6,500, and she had a live-in boyfriend that she had a supportive relationship with, even though the court called him simply a roommate. We'll go through that in a minute. But in essence, she has $2,500 from her boyfriend, $6,000 from her own income, $6,500 from her own income. She has $9,000 in terms of support. That's before child support. So her income from those two sources exceeds her needs. There is no basis on this record for an award of the $1,500 a month in terms of the alimony. There's no predicate for it. So I understand what the court said, but when you look at the record, it doesn't jive with what the court did. Also, she receives child care as part of the guidelines, $2,200 a month. And in addition, there's a double counting. My client's required to pay a pro rata share of her child care even after it being factored into the guidelines. So
that's the $838 medical?
That's the insurance. That's the health insurance. The health insurance is another problem in terms of the guidelines because the record evidence was that these children are on Medicaid. They don't have a health insurance. I think there may be a concession of error. We'll have to see. But there's nothing in the record that indicates $838 a month. So the guidelines have at least those two errors in it, in addition to income errors on both sides. Didn't account, even though the court said the live-in boyfriend has a value of $2,500 a month, didn't add that to her income for child support guideline purposes at all. So the supportive relationship was the boyfriend said they share a bedroom. He pays a portion of the mortgage. He utilizes all the utilities. There is cleaning that's done by the child care person as sort of an overlap in duties. All of those things caused the court to find that the value of that was $2,500. However, the court completely ignored its requirements in terms of the Buxton versus Buxton case from this court, in terms of grappling with whether that's a supportive relationship. If there is a supportive relationship, that's an additional reason why there should not be an award of alimony. So for whatever reason, I agree with you.
Okay, so in going through all the factors on the supportive relationship, which factor did the court not take into account in the findings?
It found that there was a $2,500 value. It found that there is a long-term relationship. The boyfriend testified.
Long-term, Buxton was 10. This was what, how, a couple of years? And I don't even know if that was.
It's not a transitory relationship. The court didn't grapple with this, so we don't have the court's findings. The court's required to, in my opinion, and did not do what the court is required to do.
You're saying written findings on each of the factors?
Correct. The court also ignored the testimony from the boyfriend that the wife was financially dependent upon him, which is an incredibly important factor. The court just announced a figure, but didn't utilize it in any way, shape, or form. That cannot be said to be anything other than error when it ignores the Buxton requirements, ignores the fact that the totality of the income exceeds what the court assigned to her needs. Because the court didn't take her needs simply at face value. The court reduced them and said they may even go less once the home is sold. So for all of those reasons, we would submit that an award of permanent alimony, the presumption was not correct. The court also didn't award the former husband any child care. I recognize that he didn't testify to any specific figure. However, the court used $2,200 for the wife in terms of the guidelines, also said he has to pay a pro rata of hers, but refused to give the.
But is he supposed to take that number out of the air, or is there supposed to be some sort of evidence on that? And if you're saying the former husband didn't testify to that, what is he supposed to rely on?
Well, there's not a specific figure that the court awarded the former wife other than what's the 22s in the guidelines. So on top of that, he's required to pay a pro rata. It should have been even, because clearly the former husband has time sharing as well and may need child care. So I would submit, I understand that's a closer issue, but I would submit the court was erroneous in that regard. In terms of the former husband's income, the court used the expert testimony from the wife's expert, but it was 2021 income. The court is required to use current income. The only evidence as to current income was significant.
What date was the hearing now?
The trial was sometime in.
Wasn't the final order in late 2022?
The final order, if we look at the back of this, can't give you the date off the top of my head, I apologize.
I guess, you know, doesn't that factor into which?
November 30th of
evidence?
2021. November 30th of 2021.
Was the hearing?
Was the date of entry of the final judgment. I thought that was the court's question. It looks like.
Oh, I thought it was, yeah.
It looks like the trial was 5 days. I'm sorry, that can't be right. The trial took place 5 days in September of 2022. Bring to the face of
the date of judgment was, I think, November 30th, 2022.
Yeah.
So the trial
Maybe it's a
was in September, so
Was it a typo?
they're supposed to.
It says, the final judgment says done in order 2021. That must be an error of time, because the trial was clearly in 2022.
How does it work that you can't rely on 2021 data?
Because the court needed to use current income as required by statute, and the court's using dated income, using 2021 figure when the only income supplied is for current income was by the husband's expert, which was significantly different, almost $6,000 of difference. Instead of the $22,121 court utilized, the current income evidence, the unrebutted record was that it was $16,164.75.
Okay, but in the judgment itself, it says the husband's most recent financial affidavit from August of 22 reflects total monthly expenses, and the court has some credibility findings on that. Is there any credibility issues on the income?
Well, the testimony I'm pointing to is the expert income, not expenses.
Which the court can disregard.
Court can, but the court needs to say that. Court didn't say that that the expert testimony, that the court didn't believe it. And the only testimony in the record.
You're saying that the court has to say it in the order that it's disregarding the expert testimony?
Well, the court needs to indicate if it's varying for some reason so that we understand what's in the record that supports the court's ruling. There's just
Is there a
not,
case that says though that it has to be in the order? I mean, can't we take it from the order that the court must have disregarded it? Because it's.
but there's no evidence to that figure. There must be something that it ties to. There's not. That's the problem. There's also numerous, although of lower value, there's numerous assets that were detailed in the record that the court just simply doesn't deal with, and there's no contrary citations to this. There were 3 checks that the wife received, $6,334.18. The court doesn't deal with that. There's a Coinbase account with much dated information, $2,285. There's no evidence that currently existed at the time of trial. There was a Suburban that the husband was required to buy from the wife during the pendency of the case for $8,000 that the court attached a value at $26,734, even though it had already been acquired during the case from the former wife with no explanation. There were precious metals that our expert testified were $55,000, and the former wife admitted, or the wife admitted she paid Older Lundy, her prior firm, $27,000 of it. The court didn't even address that in any way, shape, or form.
You know, you're going through these sort of seriatim, but let's go back to the 6434 and the insurance checks. You say that there's no evidence that that amount wasn't distributed as part of the equitable distribution of the bank accounts, right?
Correct.
But the problem is, didn't former husband's expert testify that, or was it former husband's expert? I'm sorry. That's right, I'm sorry. You couldn't find where it was deposited into her account to begin with. That was the issue, correct?
I don't think that, so we couldn't find, I think she said she cashed them.
Right, that was the problem. It was never,
Well,
it
she
was never
cashed,
deposited into her account to begin
right,
with.
she cashed them,
Okay.
received the money, but there's no accounting for that. So
Okay.
there's no accounting for all these drips and drabs, even though there's a requirement that they be dealt with. There's a firearm. The court said that the former wife didn't have it, but there's just zero evidence to that effect. There's a Nova Southeastern tuition payments my client paid on a voluntary pay basis post-filing, certain tuition payments for the former wife of $12,552. It was refunded. She didn't attend. It was refunded by Nova Southeastern, and for whatever reason, the court included that as an asset of the husband, even though it was simply a wash. It wasn't a receipt of money. It was post-filing, and he just received back what he had paid. So it was not an asset in any way, shape, or form. There was her receipt of $11,185.24 that she netted from selling guns and jewelry, not dealt with by the court in any way, shape, or form. There was unrebutted evidence that she took certain personal property when she vacated the home in New Zealand. The court didn't deal with that. The court simply said that the parties needed to equitably distribute equally the personal property, even though that was impossible based on her taking certain items.
But didn't at trial the court specifically asked if there were particular items that needed to be specifically addressed in its order? Otherwise, he was just going to order that all personal items would be sold and divided 50-50.
I think
So the court specifically invited the parties to tell the court, what particular things do you want? And apparently the parties never did. So we're in the record then after the trial, because apparently it wasn't during the trial, or at least it wasn't up until that point. Where specifically in the record was that discussed?
I think specifically in the record, let's see.
Because the court said something like, well, you can get me that information by next Friday, or something like that.
I don't specifically recollect that. I apologize. I think that both parties specifically testified as to what items they wanted. And while I'm sitting here listening to Mr. Spani, I'll try to find you a citation. I have the transcript here. I can't quote it to you right this second. I apologize. My client also was very adamant that he wanted the New Zealand home kept for access to his children. He believed that the services for medical care was better in New Zealand, so he objected to the sale of the home, and the court overruled that. There's also an overpayment of child support on a temporary basis of $28,013.
But what's the issue with the home though in New Zealand? I know there's some.
It's a very strong issue to my client, and he wanted the court to grapple with the issue of, he believed he could keep the home.
What's the legal issue that is error by the trial court?
I think the court had the discretion to make the court's ruling that he did. My client is simply asking you to take that into consideration.
Okay, because I mean, it's a home where neither of them are living. Okay.
I understand.
Point taken.
There is the child support credit. And then in terms of the time sharing issues, my client very much wants time sharing in Texas, where he's a dermatologist. The only really opportunity he has for that is over Christmas, according to the court schedule. And the Christmas 2 weeks that he receives are truncated because of the school schedule. So he really doesn't have the opportunity to go to Texas. He asks you to take that into consideration. In terms of electronic time sharing, he's only given 3 times a week for electronic time sharing. He would contend that there's no basis for any ruling by the court that the electronic time sharing that he receives is not in the children's best interest. And he asked the court to use its power to indicate to the trial court that there needs to be more extensive time sharing.
Is that clearly what the order says? Because to be honest, I found the order certainly ambiguous, but the box about the limited contact is not checked. Instead, the box about allowing unmonitored and unrecorded communication is checked. So I guess, is that how everyone has been functioning? That what it's saying is that time sharing is limited?
Yes.
Okay.
And then lastly, and most importantly, my client's a medical doctor. There was significant issues with a way that they were treating, both parties were treating the autism for the oldest child, TL, and that was a procedure using a compound called MMS. There was hot dispute over who approved of it and when, but regardless, through June of 2019, the wife was using it. The wife then attempted to indicate that the former husband was utilizing that procedure contrary to DCF's recommendation. There is zero evidence that that's true. All of the record evidence indicates that the former husband stopped using it, that there was no harm to the children from his being involved in that regard.
Mr. Sessoms, you're at your 3 minutes.
Okay, I'm going to use 1 minute just to talk about this before I sit down. There's all kinds of medical testimony in this case, but there's no expert testimony that my client's opinions about autism are contrary to the children's needs. There's no basis under the legal standard for ultimate responsibility to the wife. There's significant testimony that during the time period that she was given ultimate responsibility on a temporary basis, that she didn't tell the husband issues like the fact that she was dosing the children with marijuana, that she'd gotten a doctor to recommend that one of the particular doctors was dosing the child not only with marijuana, but lorazepam, which is contraindicated. My clients objected, asked for second opinions. There's nothing wrong with that. He also had issues in terms of another therapy called chelation therapy, and asked for a second opinion of that when the dosage that the doctor was using was beyond what was recommended by the appropriate protocols. So all of the evidence in the record indicates that my client acted appropriately, that he simply asked for second opinions when he disagreed with the doctors, and that there was no negative effect on the children. So we would ask the court to overrule the finding as to ultimate responsibility. Thank you.
You'll have 2 minutes for your rebuttal.
Thank you.
Please support Judge Bruning on behalf of Appellate, former wife Julie Landero. The first thing I'll address is the permanent periodic alimony, which I believe was appropriate to short-term marriage, almost moderate-term marriage. My client, and there's record evidence of it, was the primary caretaker of the autistic child. There's 2 children with autism, but the oldest has severe nonverbal autism and requires a lot of care. So her ability to earn money, she's a nurse and she could work 33 hours a week and do all of that, but the record evidence that the judge found is in the history, she had all these jobs, they're all PRN, and she's not guaranteed money unless she works. And if there's a problem at home with that child, which often happens, or there's a problem at school with that child, which often happens, and the wife has to leave the home, she doesn't get paid.
But is this additional money, an argument from this assessment, that this is just additional child support, not alimony?
No, it's alimony because the care of the child affects my client's ability to work. So that's the beginning and the end. And also the parties had a pretty affluent lifestyle. My client's ability to work is just hampered by the care of the child. And they had the child during the marriage. And the Reeves case is on point. It's something that happened during the marriage, which precludes the wife to earn as much money as she can. Now, during the marriage also, the former wife helped the former husband build up his practice and work for his practice. The parties agreed that she would stay at home and take care of this child and the other 3 children while the husband was able to build his career as a dermatologist. The alimony
Is the alimony that was awarded more than she needs based on her expenses?
No. No, it's not more than she needs. It's probably less than she needs, but it's not more than she needs. And the court certainly took that into account. It's $1,500 a month, so the court didn't award a lot of alimony, and the wife also needs to attend various appointments, medical appointments and therapy appointments for this minor child and possibly another autistic child. And it takes a lot of time out of the wife's ability to work and earn money. It just does. And if the wife has childcare and that person quits, and she's out of luck and she has to go home and take care of that child, it's a big responsibility. It's just impossible to work full time. Even though she has the mental and physical ability to do so, the child precludes her from doing that, on top of having 3 other children. So I believe if there's any case that is perfect for permanent periodic alimony in short-term marriage, it would be this case. It is directly analogous to her being disabled during the marriage, only it's a child. And that child being disabled attaches to her because she's the one who has to deal with it, because that child can't. So it's all her, it's all mom, it's primary caretaker, while dad is in Texas.
Could you address the issue of the $2,500?
The $2,500, yes, the court specifically found that the wife's income, including imputation, is $6,500.
I thought, I mean, the appellant's counsel can correct me if I'm wrong. I thought the point was that was without imputation, and that the $60-something hundred was prior to imputation.
The final judgment.
Well, are we talking about imputation of the support relationship?
Well, first of all, supportive relationship shouldn't even apply in this case because 6114 states
What was the finding about the $2,500?
that neither the wife's testimony nor her boyfriend's testimony was credible as to their sharing of expenses, that he is a roommate and contributes to her financially, and that the court found $2,500 to be a reasonable imputation.
Right, so then, the calculation, if the calculation prior to that is in the $60-something hundred range, doesn't that be able to take into account, shouldn't the $2,500 be added?
No, the final judgment specifically says that the wife's income with imputation is $6,500. But I do not think that it should be added. That is her total income.
But let me follow up with that. The $2,500 is taken into account as tenant income, and it's allocated to the former wife for the purpose of the court's analysis on alimony. I think that's what I can tell from the order. But does that $2,500, so by putting it as tenant income, that doesn't allow then the court, when it comes to child support, to put that in the column for child support, correct?
It is in the column as child support. There's $6,500 of
As
taxable wages in the wife's column of the child support calculation.
the $2,500 is.
Well, there's $6,500, which I believe.
You're saying it's the same?
Yes, it's
Okay. Okay.
it's all the same. And the thing that's difficult about this case is actually the whole case, but the thing that's difficult about the case is that while the wife can earn such amount of money, she normally wasn't working all the hours that she could because.
Until the petition was filed, she was working more
Well,
hours.
she didn't work really at all until the petition was filed, but even when the petition was filed, husband's in Texas, and she's trying to work full-time and trying to take care of the children, and the court specifically finds as to the husband that he has money to do this, money to buy a new office condominium, but doesn't follow the court's orders and pays for things.
Okay, so let's walk back to the supportive relationship. The court makes certain findings, makes some findings on the credibility, doesn't really know what the relationship is, but it doesn't necessarily reach the supportive relationship under the statute. Does the trial court understand that the statute requires that the trial court has to make written findings? What is your position in written findings on each and every factor of the statute?
Well, it's simple. Statute 6114, the supportive relationship at the time, doesn't apply to the case. Because the statute in its plain language says the court may modify an existing award of alimony after final judgment if, and then it goes on to the supportive relationship factors. This is an original final judgment. So the court, that the supportive relationship doesn't apply.
Because it's an original, you're saying it's an
Yes,
original dissolution?
That's a modification statute. That's not an original determination. All those factors are laid out in 6108.
Does that matter if there was a finding of imputation? And then there's a miscalculation based on the evidence? We find that the evidence is that her income prior to imputation is, 50-something hundred to 60-something hundred prior to, and would it matter that 6114 doesn't apply?
No, because the judge imputed the income to her. So the judge, it's sort of like 6 1 half does the other, there's no supportive relationship. Even if that statute applied and the judge went through all the factors and he found, well, it's $2,500, this still doesn't, maybe it reduces her need for alimony, but it doesn't terminate her need for alimony. So the judge.
Okay, so we're talking about the fulcrum point here. You're setting up this discussion as alimony or no alimony, as opposed to a discussion about whether it was calculated, the decision on the amount based on the correct calculation of.
Yes, and one of the things that is difficult on the appellate stance in this court is the final judgment stating both parties are very manipulative and have loose affiliation with the truth. There are so many credibility issues with this case that I believe it just has to be left up to the discretion of the trial judge who spent 5 days in trial and 60 hours in temporary hearings and more time with these parties than he probably cared to. So that's, it's just up to the judge's discretion as to that issue, as to what he found as to credibility, as to what the judge found as to expenses and need. So I believe that permanent periodic alimony was appropriate in this situation. And as the ultimate decision-making authority, the court specifically found in this record evidence, first of all, regarding the MMS, it's a bleach-like substance, and the husband is a doctor who is administering it to his child. The court specifically found that if the doctor could, if there wasn't a court order against it, the doctor could and would still be administering MMS to the child. The case law, and this court has held, that hostility that reasonably would lead to one to conclude that the parties would be unable to effectively work together for the children's best interests would support a finding of ultimate decision-making authority. This court found this in the best interest of the minor child to have ultimate decision-making authority over medical decisions. It also found that the husband is unable to co-parent for medical decisions. And that makes it in the child's best interest. And I'll argue further that you have a child who is special needs and autistic, and let's say that there's a disagreement and the parties can't get to court for 2 months, and then that child's not getting care. So it is in the child's best interest to have some decision, for the mom to have some decision-making authority over medical decisions. And in terms of child support, I do concede error. There's no $838. The wife was not paying health insurance at that time. So I will concede that that is error, and I spoke with counsel last night about that. I said, oops, sorry, just saw that. So I apologize to the court that I just picked it up and noticed that this was a very difficult, case. In terms of the equitable distribution, we had an expert that was on the case for a very long time. The husband has mass amounts of credibility issues, saying he has no money, but he has a Jaguar, he has a Camaro, he has a BMW M3, he has a Ford F-150 Special Ops Edition. He bought a new office condominium.
I understand what you're saying, but it only gets you so far. There still has to be some evidentiary basis in the record for the court's findings. And going through your brief, there seemed to be a real dearth of citations to the record to support those findings. So what I would find really helpful is with respect to the valuation and distribution of certain assets, is if we could go through each individual one and you could tell us where in the record the evidence is that supports the trial court's findings as to each one. Because there is no question that the trial court worked very, very hard to get this right. But at the end of the day, again, that only gets you so far.
Well, I can't point specifically to where in the record it is at this time, Your Honor, but I will say that our expert compared both equitable distribution sheets and pointed out the differences to the judge. And I can go by and tell you that if a client cashes a check, if somebody cashes a check, and the money's not found, or there's something that's sold and nobody knows what happened with the money, there's no evidence that dissipation was committed in this case. So if
well, for example, if there's evidence that she received over $6,000 in insurance checks, but there's no evidence that those checks were ever deposited into her bank account, is it a reasonable assumption, is the reasonable assumption that she cashed those checks?
That would be a reasonable assumption, I would think. And
okay. And those things go both ways. I mean, with the Coinbase account, if there's evidence that that money, if the over $2,200 was in the Coinbase account, and there's, then that's the evidence the court makes its findings on. But my point is, there's got to be some evidentiary basis, and just saying, oh yeah, there was lots of evidence. You know, we got a 1,500 page record.
And I understand that, Your Honor, and it's all in the experts' tables and where the expert, Mr. Stahl, testified to, and that's what the judge considered, Your Honor, and the judge listened to both experts and made his determination as to the credibility and he was in the best position to do so. So I don't see how they should be overturned or touched.
Can you address the tuition? The storage tuition is probably not the most precise term.
I can, it's in testimony, and I believe that my client paid, you know, I really can't, because it was a confusing issue, Your Honor, in the record and in the testimony that came up at trial, from what I recall. It was a confusing issue, the tuition checks. And I know that tuition was paid. I think my client had to pay it back to Nova Southeastern herself, even though the husband said he was, and then the money went back to him. So it's a...
So that seems like irreconcilable to me when reading the hearing. Counsel for Appellant is saying that your client didn't pay.
From my understanding is
Didn't have
that
to pay.
my client did pay, and there was a question of...
Where's that record that she paid?
And I'd have to go back and look. There was a lot of weird stuff going on with the parties in this tuition check. I think it was paid by a credit card, and then the husband put the charges, you know, did a charge back, and then my client had to pay it, and then he got the money back.
Where in your brief do you assert that she paid it?
Yes, that is my understanding.
Okay.
Yes, that is my recollection, is that she paid it.
No, in your brief. Yeah, I might have missed it. I definitely admit that I could have missed it. But that, I don't want to believe the point if we don't know off the top of your head. So go on, my colleagues can the topic if they like.
Can you address the limited communication 3 times a week?
Yes, I can. There were a lot of issues during this case regarding communication, regarding the iPad and FaceTime. And it caused a lot of problems with the parties, with the wife's ability to keep a caretaker. It just caused a lot of issues. So I guess the judge and the guardian ad litem thought it would be in the best interest of the children to limit it to that amount of time.
But didn't the trial court find that all the big hullabaloo over the communications was totally overblown and false? And there was absolutely no reason to prevent the former husband from talking to the children?
Yes.
Okay, so having made that finding, how can we assume that the court nonetheless decided that limiting his communication with the children was in their best interest?
I don't know that it's limited. It's just 3 times a week. So
You don't consider that limited?
in this case, Your Honor, I don't. In this case, when there are so many issues and so many problems with the communication.
But what are those to make it 3 times? Because you would agree 3 times a week in a week, 7 days is limited.
And
Mr. Chapani, I'll let you answer this question, but then you're out of time.
okay. And I think, and this would be guessing at what the judge was thinking, what the guardian ad litem was thinking, but that it disturbs the children's schedules and disturbs the schedule of the autistic child. It's difficult for everybody to coordinate the different timings and the communications. And the parties both have issues getting along to do just about anything.
Excellent.
May it please the court, to answer your question, Judge Atkinson, specifically in the record on page 901, 902, And in the final judgment on page 38, it specifically says that my client paid the tuition for the Nova Southeastern. So with all due respect to counsel, I think that there were findings in that respect. In terms of alimony, if you look at page 19 of the final judgment, it specifically said, so I understand what Mr. Shapani is saying in terms of a gloss of the circumstances, but the court has specific findings that are in contradiction. The court specifically said she earns $40 an hour. The court specifically said she works 36 hours a week. When you do that math, you come up with $1,440 a week. When you multiply that by 4.2 weeks in a month, you come out with $6,048. The court also said, in terms of how it got to $6,500 and why it said that there was imputed income, that she can work more once the husband has time sharing. So specifically, the $6,500 was her earnings. And to say that it's different ignores what the court found in terms of its factual findings. Clearly, the court did not add in the $2,500 for the boyfriend. Clearly, the court is required to consider all economic circumstances when awarding alimony and all sources of income, specifically by the statute. That $2,500 was ignored. That $9,000 exceeds what the court found in terms of the expenses of the wife. It doesn't matter what the lifestyle was. The court specifically grappled with reasonable needs and came up with a specific number for both parties. So we would contend that that's in error. There is no finding that it's in the best interest of the children that there be medical authority by the wife. And it's contradicted by all of the testimony, other than the fact that my client, in addition to the wife, both gave an MMS treatment. The court ultimately found that that was not an appropriate treatment. There's no medical testimony about that, but the court made its finding. I recognize that, but they both discontinued it. When DCF said stop, they both discontinued. My client specifically testified that he was not using it anymore, had no intentions to. And all of the opinions that he had about the medical treatment of the children and being ignored by the wife in terms of, these children were had heavy metals in their system.
Mr. Sessom, you're out of time.
Thank you very much. Appreciate the court's attention. I meant to tell you, I don't know if I can say this or not, but I found where you were talking about the record about personal property. I couldn't find the citation that I wanted to find. I apologize. Sorry for speaking out of turn.